as well, which is good to have you online. Apologies we couldn't provide you with lunch. So Helene and I thought it would be worthwhile doing a presentation about community businesses, assets, in particular, confidential information, restraints, and protect your employees from being poached and those sorts of issues. And we did that because we have seen a lot more action in that area over the last 5 years, where we have a number of clients who have ended up with problems in those areas, and we've been giving them some advice on this from now quite a number of factors in relation to a host of issues that deal with these problems that they face. So we thought it'd be a good idea just to give you a sort of a helicopter view of how it all works, the clauses, the agreements, what litigation looks like, and what sort of evidence that you need to try and get together if you're faced with this sort of problem. So I'll start off with a presentation. Helene will then do the middle part of it, and I'll finish off towards the end. So many people that are here today with us and online invested a significant amount of money in developing a team with the relevant knowledge and skills to foster and grow your business. And there's a lot of effort that goes into that, particularly a lot of time in marketing your businesses, developing those client relationships, and making sure that that is the powerhouse of how you grow your business. With that, you end up with a lot of transparency and accessibility by employees to confidential information, client relationships, and those sorts of things. This leaves you in a vulnerable position, especially when senior members of the team decide to depart and they attempt to take confidential information or other staff members with them. Today, we're not going to talk about privacy issues. We have provided a presentation on that recently, and if there are some aspects of what we discussed today that you want to talk to us about from the privacy point of view, we're happy to assist you with that and provide you with the previous presentation that we gave. In light of the above, we're going to discuss a few key topics to keep in mind when you're protecting the business. The first one is the importance of valid and enforceable restraints, and making sure you've got tight confidentiality clauses, what steps are available to you when an employee resigns or when they go rogue, and what litigation looks like in these cases. Firstly, we'll talk about the agreements. This is what we'll call your first layer of protection. So a restraint of trade clause in a contract comes into effect when someone leaves the business, but enforcing a restraint can actually be quite difficult, and we'll go into that in a little bit later, particularly from the point of view of getting the evidence marshalled together that you're going to use. Restraints can be classified in a number of categories. First, we have the non-competition, and that's to prevent a former employee from competing against the company. Second, we have non-solicitation to prevent the employee from approaching the employer's clients. Thirdly, we've got non-recruitment to prevent the employee from recruiting other employees from the company. And fourthly, we have confidentiality, and that's to protect the company's confidential information and trade secrets. What's been interesting is there's been a bit of news in the press over the past 6 months, and before that there were a few rumblings about whether the government would look at dealing with the enforceability of restraints, whether they would get rid of them. My view about that is I think that's a very bad idea. A lot of work goes into companies in making sure that they develop their business in a way that gives them the ability to then on-sell something that they've got. And if you get rid of restraints or even water them down, think there's going to be quite a significant impact moving forward in that area. And I don't think the government's really thought that through as to the impact that it will have long term. So let's deal with non-competition clauses first. So first, a restraint of trade is presumed to be void as against public policy. So that means the idea is, at first instance, it's not enforceable. So what you need to show as a business is that you can rebut that presumption if there are special circumstances that demonstrate the covenant is either reasonably necessary to protect the business's legitimate business interest and reasonable in the interests of the public. Now, it's well established that employers have a legitimate interest, and that is where the employee has access to confidential information that goes beyond mere know-how, in other words, how the business is operating, and they may be in a position to use that knowledge to the employer's detriment. Secondly, to protect trade secrets and business goodwill. And thirdly, where the employee's work involves personal contact with the employer's customers, and they may be able to use that connection to entice those customers away. Now, today we're going to be talking a fair bit about the relationship between the employer and clients. Those, the way that operates is very similar to what's put in place between the employee who leaves and trying to take other employees with them. So same sort of issues arise. So we thought rather than just focus on employee-employee relationships and making sure we discuss those, we thought we would also talk about employee-client relationships. Secondly, the clause to be considered needs to be considered at the date that parties entered into the contract. This ensures that you take into account the individual's role at the time and you create the most suitable and appropriate restraint. Thirdly, the clause is to be approached by ascertaining the legitimate interests that are entitled to be protected and determining whether the clause is broader than reasonably necessary for the protection of those legitimate interests. This means that an employer should not just apply a blanket restraint prohibiting, for example, an employee from working in an industry for 12 months. Now, one of the things that we see, particularly when we get to the litigation end where Len and I operate, is that a lot of employers they'll get from a lawyer a employment agreement, it'll have a restraint, it'll have a confidentiality clause in there, and they say, oh, that's good, they've used it for this employee, and then they just roll that out across everyone. So you will have, it's not bespoke in relation to each employee or each category of employee, and that's really important. We'll talk about that a little bit later. So you need to carefully consider what needs to be protected and how you can do this. So the factors that are relevant that you need to consider are seniority, influence, impact of the employee in the workplace, and in particular with clients. For example, if you have a professional whose key responsibility is to focus on client relationships, involved in marketing, or they're a senior manager or something like that, you need to consider tailoring clause that prohibits them from working with clients or having direct contacts with clients moving forward. If you're looking at someone who's, for example, an admin assistant, a lower income, doesn't have a lot of contact with clients, then a restraint clause that would be the same as someone who's a lot more senior is not going to be appropriate. Sorry, just okay. So lastly, the court can read down the clause by striking through sections with what's called a blue pen. However, the court won't rearrange or rewrite the clause to make it enforceable. So this is probably a really important part of how restraint clauses operate. A lot of people think, okay, we'll put these cascading clauses in there, so we'll have, you can't operate within 5 kilometres, 10 kilometres, 15 kilometres, 20 kilometres for 3 months, 6 months, 9 months, 12 months. And they think that's okay. The court will then just pick the appropriate fit and decide that that's how we're going to enforce it. it's not that simple because the court will actually carefully look at what you're trying to enforce and whether it can rewrite it. And the court doesn't like actually doing the work that the employer should have done in writing the clause in the first place. So a good example of that is one of the leading cases, which is Just Group, the one that's there at the bottom. In that case, we had Mrs. Peck was the CFO of the Just Group. Just Group had a number of subsidiary brands such as Smiggles, Peter Alexander, Just Jeans, JJ's, Portman, Jackie and Dottie. Peck was employed only for a short time, 6 months from June 2016 to January 2016, and then she moved to a new role as General Manager of the Cotton On Group. Her employment contract contained a very lengthy restraint. It was a cascading restraint that went into it's a business basically restrained working at. Court held that her contract restricted her from working with any retailers or fashion brands, not just those who would be in competition with the Just Group. And the contract had the effect that she couldn't work with companies unless Just Group's confidential information was being impinged on, or they weren't a company that was on that list of 50 companies. So they held that in the first instance, even the minimum, which was the 12-month restraint clause, they considered that the circumstances that during her probation period, they could terminate her employment with 1 month's notice, but then not expect her to work for 12 months after completion was not a reasonable clause. So on appeal, by the Just Group, the court held that a list of 50 businesses was not a separate restraint that was capable of severance. So I think the way that the Just Group had thought that it might operate was that they listed 50 companies and they thought, okay, well, you have to use this clause. The court might say, let's get rid of that one, leave that one. And the court said, we're not going to do your work for you. So the disputed clause must, it's what the court said, the disputed clause or sentence must be capable of simply being removed, as if crossed out with a blue pen. That's where it comes from. Court can only remove words from a restraint clause. It cannot rewrite the restraint clause. The part of the clause to be severed must be independent and capable of being removed without affecting the remaining part. It is important that the courts are reluctant to engage in a disentanglement of unreasonably wide restraint clauses if the clause is not a genuine attempt to establish reasonable protection for the legitimate interests of the business. For example, if the restraint clauses include patently unjustifiable restraints that might intimidate the employee, if the restraint clauses are in a standard form, or if the variables are numerous and the combination of variables appear mechanical and indiscriminate. So you can see from those last 3 points that I just raised there that the court doesn't want the employer to basically use a rote method of these clauses. They want some thought that goes into the circumstances of this employment relationship and how the restraint should be. And the second case I've got there is AGA Assistance to Struggling Property. That's the Court of Queensland's case where they considered the reasonableness of a trade. In this case, there was a lot of evidence that the former employee had a senior and influential role with the company and had direct dealing with key clients. In that case, the court considered that what is important in assessing the reasonableness of the restraint is that the former employee's role brought her in frequent contact with key clients who were likely to be influential in granting new or future business for the employer. The court felt that the former employee was the human face of the company and she represented the business to those clients. Therefore, the relevant interest to be protected was the relationship the former employee had developed with clients and which were acquired in the course of her employment. Therefore, they decided that it was appropriate to enforce the clauses that were in place. Let's move to non-solicitation. It's a little bit different for a restraint, and you'll get a better feel for it as I go through some of the cases. Often, restraint of trade clause and non-solicitation clause are drafted together to form a cascading level of protection. And you'll see in most contracts dealing with employment situations and dealing with restraints, you'll see the non-solicitation, you'll see the confidential information, which forms part of the entire protection. Now, this is necessary because the bar to impose the more onerous restraint of trade clause is higher, and as such, there will often be circumstances where the non-solicitation clause is enforced and the restraint of trade clause is held to be unenforced. So the idea behind that is, whilst we think it might be inappropriate for us to restrain you from doing something, what we will do is make sure you can't abuse the clients that you're working with, or alternative pitch employees. So solicitation has been given a very broad interpretation by courts, and acting upon contact initiated by a client or a former employer may still be considered to be solicitation. So a lot of people, when they are thinking about are they breaching a non-solicitation clause, they will work on the basis that I'll somehow get a message to this client and I'll wait for them to contact me, and when they contact me, that's all good. I'm okay to go. That's not the case, and the courts have basically said that. So we'll have a look at that first case, which is Barrett's. So Barrett was contacted by an officer of Nestle days after leaving employment at Echo, where he worked, to submit a proposal as an industrial consultant. Barrett submitted the proposal and subsequently attended a meeting with Nestle. Nestle proceeded with Mr. Barrett's proposal. So Barrett's thinking, okay, I haven't made the contacts and they've come to me, so I'm all good. In the proceedings that commenced against Barrett, he contended that he did not canvass, solicit, or entice any client away from Echo, as he was invited by Nestle to submit a proposal. He did not make the initial contact. At first instance, it was held that although Nestle provided Mr. Barrett with the window of opportunity, it was Barrett who solicited and enticed Nestle through his proposal. On appeal, the judge stated that the meanings of the word solicit include to call for, to make request of, to petition, to entreat, to persuade. So as you can see, it's quite broad. The judge concluded that Nestle's invitation was the catalyst or trigger for the solicitation by Barrett, and that this did not make Barrett any less the mover for the action happening. As a result, the court held that Barrett solicited the business of Nestle by submitting his proposal to them, despite not having made the initial contact. I think that's really quite important. And we've seen that, we'll talk about it in the other two cases, but we've seen that in circumstances where, for example, people put something up on Facebook or other social media about the fact that they have left a place and gone somewhere else, and the courts have interpreted that as being solicitation as well. Second case about there's Pearson and HRX. So Pearson was the employee. He held a unique position in the firm, fostering the relationship between the clients and the company, HRX. And the court, this is the full federal court, said that Pearson was active in the establishment and direction of HRX's business. And during his employment, he had access to virtually all of HRX's confidential information. So he was quite a pivotal person in the company and was described as the rainmaker. In the position, Pearson had insisted that HRX staff be subjected to some level of post-employment restraint after they left HRX's employment, and he himself had negotiated staff restraints on behalf of HRX. So he certainly knew that restraints were in place and they would be enforced. The terms of his restraint were negotiated over a period of some months, and as agreed, provided for his so to be paid to him by HRX during all 3 months of his restraint period. Given Pearson's control over the customer connections, the court was satisfied that the post-employment restraint, which included a non-compete clause, was a reasonable measure to protect legitimate interests of the business. So this could be a bit of an example of someone who's in a very senior position with a great influence on the company. The court is prepared to say that we will allow the non-compete clause
sit there and not officers using officers and technical, but they're that extra step that they said the non-certified provisions were not operating as HRS from the risk that is customers, knowing is to choose to move into the seller to ungiven by TSM and without even discussing the move with him. That's why they thought the non-solicitation wasn't going to be enough. In trips and DMPs, the Judson Brereton maintained that where the former employee has a strong personal connection with the employer's clients, solicitation clause is appropriate. They were not to say, we were not to say a stronger customer connection that the employee of solicitation is required. The strongest connections are those who rely or follow because of his or her connection with the employee, notwithstanding that connection loss of the employer. An anti-solicitation clause is sufficient to protect an employer's customer protection in that context. That gives you a good example of the stronger the relationship with this person has with clients, with employees, whatever, the court will then take a stronger stance in relation to if is appropriate or step up to the restraint. Next section I'm going to deal with is
Thank you. So I'm going to dive straight into the confidentiality. Now, implementing a strict duty of confidentiality in any agreement will also provide another layer, a very important layer of protection for employers. So there is no specific law that defines confidential information, so we have to turn to the common law to see how it's treated there. Generally speaking, confidentiality refers to keeping information or knowledge, secrets, and preventing unauthorised access to personal information. So when it comes to agreements, we would always recommend that a rather broad definition of confidentiality is incorporated into employment agreements or any agreements with suppliers and contractors and so forth. So it should include things like, when this focuses on use of property, things like ideas, know-how, concepts, trade secrets, processes, techniques, software, products, and everything associated with intellectual property. There's also the aspect of financial and business information and all other commercially valuable information which your company regards as confidential. So, for example, depending on your business, you might be looking at supplier lists, there might be prices, there will be your business's affairs, products, and any other data that isn't actually publicly available. Now, the aim is very much to capture all of the information that is about a company during that is obtained by an employee or someone that works with the employer, that is by its very nature confidential. The practical implications of this is that it means that if somebody has obtained confidential information whilst working for the employer and they use that confidential information, shall be breached of their obligations. Now, it's also very important to note that the confidentiality extends beyond termination of your employment. And now, in our experience, addressing a breach of confidentiality clause is probably one of the most efficient mechanisms that can be adopted because it is a quick way to have material return to you and provides a good mechanism to protect your business. The damage arising, and this will be discussed also a bit later on, but the damage that actually arises from the misuse of confidential information is actually very hard to quantify. And it's because the damages is actually not an adequate remedy. Some extra information and supply to a direct competitor because the goodwill of the business is obviously severely impacted. So looking at 3 cases today, very quickly. The first one is fraud. So this is somebody here. This is also allegation from the breach of the confidentiality against 4 employees who are actually financial advisors. Now, these employees had access to and downloaded confidential information. It was alleged that they then provided confidential information to a competitor and then they knew employer who were short answers. So prior to the information, the respondents actually downloaded a sample amount of confidential information on their desktop computers and then smart razors and relatively simple. Now, this confidential information included client files, and it also included confidential employee files about other staff members that worked with the project. Now, the respondents didn't provide any satisfactory explanation of the downloading of this material. Something like I think there was one. Now, they then resigned in November 2022. They noticed this period expired in December 2022. And then they moved over to their new employer, Shaw Partners. And along with that, from a period of December through to January, total 43 clients. That's a lot of clients in a very short period of time. So the court may notice that the defendants be restrained until we get a further order, including the defendants and their bosses, agents, employees, from using that information. And interestingly, they also took it one step further, and this is something we'll touch on a little bit later on the West Link 59. And the court also satisfied on the evidence that there was private case against Shaw Partners that they had evidence presented outsourcing and children that were normally concerned in the defence cases. The next case I'm looking at is one of the three. Now, in this case, I like this one. It's a little different. The defendant emailed confidential information to the police. So that was ABC journalists and also the Department of various solicitors. Now, he actually took photographs of confidential information. So the top confidential information was contained on a whiteboard that was located in the room in the applicant's premises. And that room had to access, but the defendant was one of the individuals that had access to that room and was after the whiteboard. And he emailed a lot. Now, that whiteboard had confidential information such as customers, particulars about products that have been bought by customers, confidential information regarding exit procedures. He then emailed those photographs also to a direct competitor. Now, the court found that there was a strong argument case, indeed, one that the defendant breached confidential engagement through issuing the employment contract, as well as his options under Section 183 of the Corporations Act. And the court found that it could safely be inferred that the plaintiff's competitive position had compromised and undermined as its confidential nature, including customer detail supplied by those customers, and had been invited to at least one competitor. The court made orders restraining the defendant from disclosing that confidential information for a period of weeks, as well as delivering out plaintiff's confidential information and destroying and deleting any electronic copies and possession. Now, the one other case we'll look at is the one about that. Now, that's a Supreme Court case, and it's actually ultimately related to the together. And the reason why we're looking at that is sometimes you learn more from your losses than you wins. Now, this case very much demonstrates the importance of consistently and collecting as much evidence and information as possible regarding original confidentiality. And now, in this case, the court ultimately dismissed the application by the plaintiff seeking injunction to restrain the defendant from using confidential information or delivering out that information. Now, the plaintiff operated a real estate agency, and the defendants were former employees of the real estate agency. Now, the defendants commenced employment with a new real estate agency, 500 Keys. And following their determination and their respective employment with the plaintiff, They had a total of 14 landlords transfer over to 500 keys. The plaintiff contended that the defendants utilised their confidential information to acquire the business of over 14 landlords, and the defendants contended that the business came to 500 keys at the of the landlords. Now, we'll consider two main issues with this application. The first one is the evidentiary issues, and the second one is the delay. Now, evidentiary issues in the court said that there was little to no evidence that would support finding that the defendants downloaded any information from the plaintiff's database prior to their termination. There was no forensic information or technology investigation undertaken by the plaintiff to establish any evidence that the defendants misused confidential information. They didn't establish any discussion between the plaintiff and any of the landlords, and any discussions as to whether the landlords had been contacted in the first instance by the defendants. In respect of delay, the court was critical of the delay in the present proceedings in circumstances where the actual transfer of the clients that occurred around October, November 2018. The plaintiff didn't commence proceedings until May 2019. So ultimately, the court said that there was no case. The patient was deceased. So another element of the is the independent clause. So this is a factor to be wary of. And this is something that I've come across quite a bit, is that each entity actually suffered the loss. The corporate structure is complicated and complicated. Often an employee is engaged in a separate company or entity than the services that are being carried out. And this can create an issue that will actually suffer loss. Therefore, in our experience, thought should certainly be given early on when it comes to drafting to include an indemnity clause in any employment contract or other contract. So, by way of example, like I said, we often see by the agreement that there's an employee entity, so company A, and then the entity that's providing the services, which is company B. We would like clause to exist, which finds that the company B suffers loss by reason of the actions of company A, agents and employees. Then the company B can recover loss from company A. Then, ultimately, the indemnity clause is to be inserted in the employee's contract, enabling company A to then claim the loss of damage suffered that it's had to pay the company B. The clause must obviously be very carefully drafted, and we highly recommend that advice because we don't want to put an issue forward. And there must be a coordinated link between the actions and the breaches and the ultimate loss and damage suffered. Now, the liquidated damages clause is also another very attractive clause to be served from an employee's perspective, and it's quite difficult to certify. Some clauses provide certainty and does away with the purpose of the task of assessing damages payable for the occurrence of an event, which is typically a contract. The liquidated damages clause is, however, susceptible to challenge on the grounds that it may effectively be a penalty and therefore is unenforceable. So it has to be very carefully drafted and thought out. Courts generally do uphold the liquidated damages clause on the basis of the principles of freedom of contract. But like I said, they are susceptible to challenge on the grounds that they are a penalty. Now, the leading case on penalties, and I'm sure you may have heard of it, it's a High Court case of ANZ Bank. Now, in this case, and skipping to the key aspects of it, when determining whether a clause is a penalty, the High Court makes key observations. The first one is the essence of the liquidated damages is a genuine pre-estimate of the damage. The question of whether a sum stipulated is a penalty or liquidated damages is a question of construction, and it's to be decided upon the terms and the inherent circumstances of each particular contract, judged at the time of making the contract, not at the time of breach. It would be felt to be penalty. For example, if the sum is stipulated to be just an extravagant figure that's just simply unconscionable in comparison to the greatest loss that possibly suffered. Or if it was a single lump sum payment in terms of several events. So you can see a lot of thought needs to be put into the process associated with a liquidated damages clause. And in our experience, an agreement which sets out an actual formula to calculate the damage is often very helpful. It's just not a simple lump sum payment with no thought process involved. And it's a formula that is a proper calculation of the loss. So, this is where this kind of starts. What to do next? When a staff member resigns, it's important to be discreet and decisive in our actions. So, you should never setting up post-employment obligations. This should be a stock standard approach. This should include information explaining what your ongoing obligations are and focusing in particular on keeping the confidential information confidential. Set out the consequences of non-compliance and request any confidential information that is in the employee's possession be returned immediately. Consider monitoring and undertaking forensic analysis of the employee's computer, mobile telephone. You want to try to see if things have been downloaded, printed, created, deleted, saved. Monitor social media accounts. So this is a new age element. You want to have a look at LinkedIn, Facebook, see what's being promoted out there. You want to monitor your workflow, and if there is something wrong, like we said, we need to act quickly. And that's where we turn to the litigious options. Like I said, specific and decisive steps are required. You believe that a former employee has taken confidential information, is using confidential information, or is in breach of restraint, you have to be quick about it. First, issue a letter requesting an undertaking consistent with the terms set out in the document. If there is a breach of confidentiality, that letter should specifically particularize the information that is confidential, the circumstances of the alleged breach, and demand the immediate return or destruction of that confidential information. If the undertaking is not provided, an interlocutory injunction should be filed as soon as possible. So an interlocutory injunction provides a means by which the court can hear applications quickly and in situations where time is of essence, and before any final determination is made on a permanent injunction. So it very much is about maintaining the status quo. The court will not necessarily conduct a mini trial to seek a predetermination of the outcome of the final hearing. It will not determine the credit of witnesses, and the rules of evidence are actually relatively relaxed. And what that means is that the evidence is sufficient. So it's important to remember that when making an application for an injunction, the court will require the party seeking the injunction to give an undertaking of standards. So this is a commitment to pay compensation to the other party in the event that the injunction is ultimately overturned later on. Now, the case of ACC and O'Neill, that very much outlines the circumstances that are required to be established in order to get up on an injunction. So simply, the first is that there has to be a serious question defined. The second is damages not be an adequate remedy, and the third being the balance of convenience. So if we look at the serious question behind, there's a High Court case, Castlemaine in South Australia. Now, in that case, the High Court found that in order to demonstrate that there was a serious question behind, that the plaintiff must show on the evidence that there's a probability that they are entitled to the release of support. So that very much ties into what we were talking about claiming evidence. Undertaking that forensic analysis, monitoring social media, monitoring emails, having a look at what's being downloaded. Now, damages is not an adequate remedy. Now, in the case of CETG, this is a Supreme Court case in the ACT, the court ultimately made the Australian employee working for a specific kind of his former employer for a period of 12 months. Now, in that case, it's a little convoluted. A client exercises entitlement under a contract to terminate services and then work directly with the former employee. The court was satisfied that there was an anticipated breach by the former employee of his contractual obligations to his former employer. The court found that damages were not an adequate remedy on the grounds that many employees, such as the defendant, to leave positions to take up work with their employer's client would cause the employer a very significant loss in terms of the business. And that very much touches upon the case that I referred to previously today, where the court found that the provision of confidential information to a direct competitor ultimately has a serious impact on the business. If we look at balance of convenience, that is the final element in determining whether or not injunction. Now, this almost weigh up the applicant's interests, of course. Again, the respondents to show whether or not granting an injunction is going to achieve justice between the parties. Now, the question we usually consider the effect of the injunction on the respondent and also on third parties, of course, and the availability of alternative remedies, and whether or not any unpaid fees offered by the respondent are achievable or the respondent's conduct. So, for example, again, drawing on the case that I touched upon previously, the defendant actually remained employed the entire way through the process. So he, although it was unpaid leave because he sort of called his personal leave entitlements, but he was still employed and receiving pay. So in those circumstances, the court looks at it from the balance of convenience. Now, once the injunction is made, then there's the way to present a claim to determine whether or not permanent injunction should apply. And that's where I'll hand back over to delve into evidence.
Okay, talk about evidence. This is the next step. What we need to do is collate the evidence that we are going to use to successfully pursue a claim. The difficulty with these cases is that the evidence that you want is not in your possession, it's in the other side's possession. So you've got to think strategically about how are you going to assemble the evidence that you're going to use when you want to go to court. Undertaking a forensic analysis of former partners, computers, emails, and records is really important. So how do you there are a number of people in that need to study that specialise in this sort of thing, and there's some of you come across does that as part of his work. There are a number of people like that. They've got very good access to the computer programs that will ferret into the computer and bring out a whole lot of information that you thought wasn't there. What could be interesting is things like, for example, something if they are particularly familiar with IT, they might not understand that just deleting something from your computer, dragging it into the deleted box, and then going to deleting that gets rid of it. It's still there. You can access the various programs. So things like looking at what they've been doing over the past 12 months, what confidential information has been accessed, what USBs have been in the computer, all that is recoverable information. What's been downloaded, printed, coding printed, you look at what's been printed, who's had access to the printed, how much has been printed up. So you'll be surprised at how much information you can actually get electronically. Having a look at people's diaries, how many meetings have been delayed, as it was the patient turned off until after that person leaves. Are they contacting suppliers? Are they sending things to their personal? All of that information is readily ascertainable. The next step that you want to consider is issuing notices or subpoenas against either former employees and introducing the client. So when the client leaves, there's no reason why you can't do a scenery which that client for their phone records and things like that. I've done that successfully on a number of occasions. And what's really interesting about when you do that, it's very hard to cover your tracks completely. So if someone's looking at trying to cover their tracks, they will do things like, for example, in their phone records, delete the numbers that they've been contacting and things like that. But that's only one side of the ledger. The other side of the ledger is the people that they've been contacting and what's in their records. So they're not going to go and delete that stuff for all of them. So we had a matter just recently where we got both the record on the phone records from both sides, the left to the person that are left, and the client's records, and we did them side by side, and you would see where this person is saying, no, look, I didn't listen to this, he didn't contact me. But we would see that there were calls to that number for things like 3 seconds, 5 seconds, where we obviously left a message saying, give me a call. And then the record thinking that, well, if they think those records, I'll see the call coming in, I'll see my records call coming in. Whereas I think the client record, I'll see the call going out. We're able to show the initial contact from that person. But things like that are very, very, as we said, as we said, LinkedIn, Facebook, Instagram, the next issue to consider is third party and other consideration report. Some cases it's open for you to pursue a single member for breach of duties under the corporation. We're talking about section 181, 182, and they are sections that provide for obligations of faith, integrity, and making sure that also the corporation extends its interests to the corporation. Now, there is a sort of a threshold you need to show that person, even though they might not have been in the so it's easy if they're directed to do that. So basically are obliged to ensure control of those sections. But someone might be acting as a director, even though they are not a director, and they might consider an officer of the corporation. So that's one avenue that you can also use as a enforcing compliance and looking for personal wisdoms going setting up in business. The other course of action which we use on a number of occasions and it's a good leverage against the new employer or the new company, and in that they not only assisted in a breach of fiduciary duty or stuff, but then that's always a really good way of applying some pressure right at the outset. Whilst a new employer might there's not just we know Forest Drives, but show them they'll deal with it, look back we'll look after him. But if they are also there as well, then it puts a different light on it. Now the leading authority on that case is the High Court case called the Ancient Order of Foresters in Victoria Friendly Society Limited versus Lifeland Australia Society Limited and another High Court authority. It's a very long case. It's it went in the first instance on appeal to a court, then on appeal to the High Court, and on each occasion the court increased the award damages, and each time so it just kept on getting worse for our opponents. Just to give you a bit of an idea what occurred in that case. Lifeland through its industry at the end provided products to meet the cost rate of funerals. Foresters was also involved in the funeral products business, so small market share, and Foresters' business was not that profitable. Watford Corby were 2 employees, no employed by the man. But in 2010, they approached Foresters to buy the land of the Bird Lifeland and existing funeral products business to Foresters. While still employed by Lifeland,
plan, Wolf and Corby presented a comprehensive
proposal to Forrester using the
plans for medical commercial information,
and including names of clients, referees,
references associated in the past, revenues,
whole lot of detail of what they would require to make this transition over the next 5 years. The proposal was considered by the Foresters Board and ultimately approved, and both the primary judge and the full federal court found that Foresters would not have proceeded with the plan without reviewing the proposal, including the confidential information of the life plan on which it was based. So they basically formed the view that there was a plan by Wolf and Corby and Foresters to join this to try and transfer their clients.
Wolf and Corby so rather for Funeral Planning Australia,
And Funeral Planning Australia was incorporated while Wolf and Corby was still employed by Plan. While still employed by Plan, Wolf and Corby also accepted to implement the plan, inducing the production documentation of the Foresters marketing material and attending initial
meetings with client referrals
design
in the first year.
Following their resignation from Life Plan, Plan was implemented by Wolf and Corby and by Foresters and by other employees,
And also other employees.
and it proved to be very successful. Foresters' revenue went from 1.6 million in 2010 to 24 million
In 2 years.
Life Plan revenue decreased from the 8 million to 45 million over that same period. So Life Plan at the end
Against Wolf and Corby, Funeral
in Australia breaches of fiduciary duties towards them as employees,
as well as contraventions of the
Corporations Act, because they were senior members and they were sued on the basis in relation to that they were officers of the corporation. Foresters were then
subsequently joined to the act on the basis of
knowingly assisted in those breaches. And the court held that there was sufficient causal connection between Foresters'
assistance in those breaches.
and what had occurred. And they felt that it was sufficient to show that the profit would not have been made for the dishonest wrongdoing, and it is necessary to consider the overall effect of non-assistance rather than the
Offense of each act.
They can see that the court took the view that if you are knowingly interested and you assist in the transfer of the
You're going to be penalised for it.
so it's interesting the way that
The court looked at the damages
the
full court and then high court.
that there was I won't go into this in a lot of detail because this is quite a complicated issue. Initially, they looked at what the actual damage was that had occurred in relation to each client, and then where it ended up with the High Court was that they effectively did an account of profit, and they looked at what damage as a whole was done to the business. And that ended up with I can't remember exactly what the figure was, but it was many millions of dollars. So that was that's if you can find any evidence that there have been meetings, that you all about what's going on, they had meetings, they might have given them plans of the business or anything like that. Even if they haven't, even if you can't find any evidence of that, we put them on notice straight away. We put the new employer on notice. We've got restraints. This is what they say. You've got to make sure your new employee doesn't breach those restraints.
If anything happens after that,
Then you put them on the book. So I think that's probably all I've got to say. Take away scope and many restraints and confidentiality. It's also really important that for working with litigation, don't get some advice right at the outset about what these clauses and agreements should contain in them, because whilst it might seem an expensive thing to do at the time, and you might spend $5,000, $10,000 getting a bespoke agreement for various employees, it's a hell of a lot better to do that than spend $500,000 to get a change. Remember that non-solicitation is broadly interpreted using social media through LinkedIn and Facebook providers. That's important for solicitation. And if you're concerned decisive actions, take a step straight away and get the evidence
together straight away and make sure that if you're
you're getting injunctions.
do that straight away as well.
Quite often these matters
Are resolved at the injunction level.
because if you succeed on the injunction, even if you're not going to get the injunction,
There will always be a discussion and you might be able to resolve that fairly quickly at that stage.
So, any questions for the
Lead, all right.
Thank you.